Good morning, class. Settle down quickly. Welcome to this focused exam masterclass. Today, our sole objective is to totally dissect and master question 21 on your property law paper. We're looking at distinguishing between a sale and an agreement to sell. Look, I see students losing entirely avoidable marks on this foundational concept year after year. And frankly, as a law student at Karnataka State Law University, you just cannot afford that kind of ambiguity, right? We'll use this exact visual framework to structure your answer perfectly, exactly as your evaluator expects to see it. So if you're serious about securing maximum marks and pushing your grade into that highest bracket, you need to pay strict attention today and note down this framework meticulously.
Let's look at the synopsis on your screen. 1. Introduction, referencing Section 54 of the TPA. 2. Definitions and essential difference. 3. Detailed distinction table. 4. Legal consequences. 5. Mandatory case laws. And 6. The conclusion. Listen to me very carefully. Always, without fail, begin a 16-mark answer with a clear, cleanly written synopsis block exactly like this. It is absolutely mandatory. It grabs the KSLU evaluator's attention immediately, right? It shows them your thought process is completely organized and legally sound before they've even read your very first paragraph. Let's move on.
Heading number 1. Introduction. Laying down the statutory foundation. Write this heading clearly right in the center of your page.
Read the text with me. Governed by Section 54 of the Transfer of Property Act 1882. Differentiates between an executed transfer and an executory contract. So, the distinction between a sale and an agreement to sell is absolutely fundamental in property law. As you can see, it's governed by Section 54 of the Transfer of Property Act 1882, which clearly differentiates between an executed transfer and an executory contract. Class, listen to me. Citing Section 54 of the Transfer of Property Act 1882, accurately in your very first sentence is the absolute key to scoring those initial marks. If you forget the section number or the year, you are literally throwing away the examiner's goodwill right off the bat. Don't make that mistake.
Moving to heading 2, definitions and essential difference. Make sure you note down the precise conceptual divergence between these two legal terms. Look at the screen. Sale, completed transfer of ownership in exchange for a price paid or promised, versus agreement to sell, promise of future transfer, or a contract that sale takes place in future. Okay, let's break this down rigorously. A sale is a transfer of ownership in exchange for a price paid, promised, or maybe part paid and part promised, right? It's a done deal, a completed transfer of ownership. On the flip side, an agreement to sell is simply a contract that a sale shall take place in the future, or upon the fulfillment of certain conditions. It's a promise. A sale is an executed contract. The deed is done. An agreement to sell is executory. It remains to be done. Take this precise example for your exam, okay? Let's say A agrees to sell a house to B, but only after clearing an existing bank loan. That right there is an agreement to sell. The transfer completely relies on a future condition. Do not mix these two up on your script.
Now, heading 3, the detailed distinction table. I am explicitly instructing you right now. A neatly bordered tabular presentation is the absolute non-negotiable requirement for any distinguish between question on a KSLU exam. Do not write paragraphs here. Paragraphs will not fetch you full marks. Let's read through the exact table you need to draw. Grab your pencil for the borders. First, on the basis of nature, a sale is an executed contract, while an agreement to sell is an executory contract. Next, ownership. In a sale, ownership passes immediately. In an agreement to sell, it does not pass. Third, right created. In a sale, it's a right in rem. In an agreement to sell, it's a right in personam. Let's pause right here. This is crucial jurisprudential terminology. A right in rem is a right available against the whole world. If you buy the house, the entire world has to respect your ownership. A right in personam is a right against a specific person. If you only have an agreement, you can only sue the seller, not the whole world. Use these Latin maxims to impress the evaluator. Okay? Let's continue. Possession, usually transferred in a sale, but may or may not be transferred in an agreement. Risk, the buyer bears the risk in a sale, while the seller generally bears the risk in an agreement. Remedies, a sale grants ownership rights, whereas an agreement only provides contractual remedies. Registration, compulsory for immovable property in a sale, but not compulsory in all cases for an agreement. Finally, title, a complete transfer occurs in a sale, while there's no transfer of title in an agreement. Memorize these 8 bases. They are literally the backbone of your answer. Moving on to heading 4, legal consequences. The theory is laid out, but KSLU evaluators actively look for the practical application of these theoretical distinctions. What actually happens in the real world? Read the slide with me. Legal consequences. In sale, buyer becomes owner, can transfer property further, bears risk of loss. In agreement to sell, Buyer gets only contractual right. Can sue for specific performance or damages. No ownership rights. Okay, let me elaborate on why this distinction is so incredibly vital in real property disputes. Think about it. If a house burns down a day after a sale is executed, the buyer suffers the loss because the risk follows ownership. But if it burns down after merely an agreement to sell, the seller suffers the loss. Plus, under an agreement to sell, your only remedy if the seller defaults is to drag them to court for specific performance or breach of contract damages. You can't just take the property. Make absolutely sure you highlight this practical reality in your answer.
Heading 5. Mandatory case laws. Sit up straight for this part, class. Naming and thoroughly explaining landmark case laws is the defining factor that pushes your answer from an average 10-mark bracket straight into the superior 16-mark bracket.
Our first landmark case, Narandas Karzandis versus S.A. Campdom. Here is your specific exam tip for this. Don't just bury this name in a paragraph. Write this case law in a separate, boxed format right in the middle of your page, or underline it heavily with a black pen. You need to make the evaluator see it instantly.
Let's read the exact breakdown. Facts. Dispute regarding the exact moment property ownership transfers. Ratio decidity. Held that ownership passes only on execution of sale deed, not by agreement to sell. Relevance. Reinforces the Section 54 TPA mandate for executed transfers. Now let me give you the deliberate, expanded explanation you need for your exam. The background facts of this dispute centered around two parties fighting over who held the true title before the final registration was actually complete. One party argued the agreement itself gave them standing, but the Supreme Court's final verdict, the ratio decidity, was absolute. A mere contract of sale does not of itself create any interest in or charge on such property. Ownership transfers only upon the formal execution and registration of the sale deed. The absolute relevance of this case is that it definitively interprets Section 54 of the Transfer of Property Act. It leaves zero room for doubt between an executed transfer and an executory promise. Write exactly this logic in your exam booklet.
The second mandatory case, Rambao Namdo Gajre versus Narayan Bapuji Jotra. Again, I'm reiterating my instruction here. Highlight this on the answer booklet for maximum visibility. Giving two solid case laws on a 16-mark question pretty much guarantees an outstanding score. Let's review the slide. Facts. Party claiming legal ownership based merely on an agreement to sell. Ratio decidendi clarified that an agreement to sell creates only personal rights, not ownership. Relevance. Establishes the boundary of right in personam versus right in rem. To explicitly detail this for your script, listen up. The brief facts involved a party attempting to assert full ownership rights over an immovable property while armed only with an unexecuted agreement to sell. They were basically trying to bypass the formal conveyance. The court's ratio decidendi firmly rejected this ownership claim. The court stated clearly that an agreement to sell creates solely a personal obligation. It binds the parties, sure, but it does not convey the property itself. So how does this tie back? Well, it perfectly illustrates our earlier distinction. The agreement gives you a right in personam against the seller to demand execution, but it utterly fails to grant a right in rem over the actual land. Explain this next as clearly, and the evaluator will know for sure that you've mastered the jurisprudence.
Finally, heading 6, the conclusion. Prepare yourselves for the final paragraph of your exam answer. A well-written conclusion seals the entire argument. Let's read the final prompt. Why is this distinction crucial in determining the legal rights, risks, and remedies of the parties? You will summarize your answer by stating confidently that a sale results in the immediate, absolute transfer of ownership, whereas an agreement to sell remains merely a conditional future promise. This distinction isn't just academic, folks. It literally dictates who bears the financial risk of destruction, who holds the right to immediate possession, and whether the aggrieved party seeks property rights or merely damages in court. Remember, a single signature separates a king of the castle from a mere holder of a paper promise. Memorize this exact sequential structure: synopsis, introduction, definitions, table, consequences, cases, conclusion, for your upcoming property law paper. Class dismissed, and I absolutely expect to see top marks from every single one of you.